Arkadaşlar selamlar. Bugün merak edilen trademark konusunda bize uzun süredir yardımcı olan Anton'la beraberiz. Aynı zamanda Doğukan da yanımda. Size hep beraber trademark konusunda nelerden çekinmemiz gerekli, nelere odaklanmamız gerekli, bu işin kısaca doğrusu nasıl yapılır ondan bahsedeceğiz. Hello Anton, how are you?
I'm doing well. How are you?
We are good as well. We really appreciate that you spent your time having us as your guests, because usually these kind of sessions are worth lots of money. We really appreciate you spending time with us.
Yeah, no problem. Pleasure's all mine, and I look forward to talking to you guys about trademarks.
All right. So I think you can start. Actually, before we start, maybe you can tell us how you got involved with trademarking after you became a lawyer, and your story on the trademarks a little bit.
Yeah, so I've been interested in intellectual property, even before going into law school, and I knew that I wanted to do something involving intellectual property, and I went to law school, and I took a lot of classes that had to do with the law and tech and science and intellectual property, because those things tend to come together a lot. So after law school, I started working for Legal Force, doing IP work for them, mostly focusing on trademarks, also doing some copyright, doing a bit of patent consult. And I did that for a while, and eventually I decided that I wanted to spin off, and I wanted to have my own firm where I could focus on trademark work and where I would have more time to work with each individual client than I did at Legal Force. And so I founded the Trademark Garden, which is my firm, where I do trademark work, but also general contract-related legal work for people, and that's where I am now. So I have a lot of experience in trademarks. I've filed hundreds and hundreds and hundreds of trademarks. So I really run the gamut of trademark work, and I enjoy it. I enjoy what I do, and I'm looking forward to talking to you guys about it.
Yeah, we enjoy working with you too, because we have filed so many trademarks with your old company, and so far it has gone all well. So hopefully we will keep on working together.
Great. So let's start the presentation.
Yeah, sure.
As an overview, we have the basic points: why do you need a trademark? The importance of balancing legal and marketing concerns. How do you select a strong and viable trademark? And trademark distinctiveness goes into that. What to avoid when selecting a trademark. When's the right time to file, and post-application obstacles. So we're going to talk about all of these things in turn. This is just an overview of all the topics, and we're going to get into more detail as we go on. So first, why do you need a trademark? So a trademark can actually serve as both a shield and a sword. It can both protect your brand, that is, to protect your brand from third-party challenge, and it can be used to challenge third parties that are trying to maybe consciously steal your brand, or maybe just by accident they came to have a brand that's very similar to yours, but if you have a trademark, if you have priority, you can prevent them from using it. Well, if somebody else comes along and starts using your brand name or a similar brand name, or your slogan or a similar slogan, or your logo or a similar logo, suddenly, maybe people, you have built that customer base, but then maybe they see this other person's similar brand, they think it's you, and they go to this competitor, and a trademark will helps you protect against that. So the points are, branding is an integral part of your business. As I've noted, most businesses invest fairly heavily in branding and in advertising. A trademark also helps build legitimacy to both the consumers and investors. So this actually does matter quite a bit. If you're looking for outside financing when you start the company, investors will care about intellectual property, about, is this brand protected? Is this just, you're making, this product, you're making shoes? Is it, what is the capital here? Is it just the shoe designs, the sewing machines, the whatever to make the shoes, but is there also a recognizable brand to go with these shoes? Is this something that consumers recognize, and is it protected? Can somebody just take this away from you? Might there be somebody else out there that has superior rights, or do you have a trademark registration? And trademarks help consumers differentiate between different products and services. So again, one of the primary focuses of a trademark is to identify that these are goods from a particular source. They're goods from a particular seller. So, people recognize Nike. If you take a Nike shoe and you take all the branding off and you sell it as a generic shoe, chances are people aren't going to pay for it as much as they would pay for a Nike shoe.
Exactly. Like when you enter a grocery store, and if you are going to pick up anything, let's say a toothbrush, like the amount of the marketing that those guys spend in that products are like extreme. Before you see the actual product, just by seeing the colors, you know that if you are going to get a Colgate, let's say, like it helps to create differentiation between the products so that customers can actually distinguish.
And if you notice, actually, things like toothpaste or like medicine are a good example. You notice you might have a branded medicine, say Dayquil or NyQuil, and then you might have a store brand that is the same ingredients but doesn't have that brand. It's going to be quite a bit cheaper, even though it's essentially the same product. And that goes to the power of the brand.
So, Anton, how would you suggest us to choose a strong and a viable trademark?
The main idea here is that there has to be a balance between the legal distinctiveness of the trademark and the ability of the trademark to identify the particular goods and services to your consumer base. Fanciful, arbitrary, suggestive, descriptive, and generic at the bottom. So generic says avoid in all cases. Generic would be words that just mean what the product is. So like we talked about with Colgate, so toothpaste would be generic and cannot be held as a trademark because that is just what the product is. Yeah. Colgate is, as far as I know, would be fanciful. So fanciful are made-up words. Some examples on the bottom: Exxon, Kodak, Siri. These are words that don't have a meaning in English or any language known to the applicant or the USPTO. So a bit of a warning on this point, especially for international filers. So if you're using a word, let's say the word has a meaning in Turkish, but it has no meaning in English, that will not be considered fanciful, because if the word that you're filing on has any translation known to the applicant has to present that translation. So be careful. This needs to really be a made-up word and not just a word that doesn't exist in English. It has to be a word that doesn't exist in any
that
language.
That is indeed very important, because most Turkish sellers, especially on Amazon, they come up with some Turkish word and then they try to trademark it. But since they don't know that actually the word is not supposed to have a meaning in Turkish as well, at some point I think they are experiencing problems with their applications. So this is indeed a very, very, very important topic to consider.
Yes. Let's start with fanciful trademarks proper. So again, these are made-up words. These are just words that the applicant, the holder of the rights, comes up with. So these are great from a legal perspective, and the reason, there's actually a few reasons. Number one is that these can definitely go onto the principal register. So there are two trademark registers. There's the principal register, which grants you all available trademark rights, and there's supplemental register, which grants you the right to use the R symbol, and it gives you a registration number. But if the matter ever comes to any kind of legal litigation, any kind of legal trouble, you really want to have a principal register trademark. It gets you far more rights. And fanciful trademarks can indeed go on the principal register, on the good one. And so that's very good. It's also very good because, again, in a case of infringement, so if somebody else, let's say with Exxon, if somebody else starts a petroleum company and calls it Exxon, Well, Exxon would have a very good claim that they're doing this in bad faith, that they are purposely trying to trade on Exxon's name because it's just a made-up word. And what are the chances that somebody would make up the same made-up word for similar products if they're not actively stealing it? The next point is it's challenging from a marketing perspective because if you just look at, say, Exxon or Kodak, of course, people know what these are because these are all brands that have been around, that have, permeated the market. But until you build up that recognition, a customer wouldn't know just by looking at Exxon what that is. That could be anything. It's a made-up word. That until you build up this brand identity, especially for small sellers, if you're selling your products on Amazon, you're not a huge corporation. You just have certain products. Maybe you're making phone accessories, and you have this relatively small brand. Then a fanciful trademark on its own, people aren't going to be able to immediately recognize. Now, what I recommend to clients that do want to come up with a fanciful trademark or have a good idea for one is that you can actually attach a generic term after the fanciful trademark, and the entire trademark will be considered fanciful even though the generic term is attached. So, for example, again for Exxon, if the trademark was Exxon Petroleum, that will be fine, and that entire trademark would be considered fanciful. It could get on the principal register. Everything will be great, even though the word petroleum is there. The only caveat is when you're filing, there's something called a disclaimer, where you explicitly disclaim rights to certain parts. So you basically say to the patent office, okay, we're filing on Exxon Petroleum. We understand we don't have rights to the word petroleum because it's generic. We only have rights to the word Exxon. But the entire trademark is Exxon Petroleum. And then when you use the trademark, you present it to your customers, they're going to see, Exxon Petroleum or Kodak cameras or whatever. So they're going to see that generic term there to identify to them what it is that you're selling. But you keep the legal protection of the fanciful trademark.
That's actually a very good suggestion indeed. Especially if you are selling on Amazon, I think that is the way that you should be following. Thank you for that suggestion.
Next is arbitrary. So this is fairly similar, actually, to fanciful. This is real words, so they are real defined words, again, in English or Turkish or any other language. These are words that have nothing to do with the goods or the services. So, for example, Apple for computers or for phones or for software. Amazon for an online store. Again, Amazon is a rainforest, but has nothing to do with
online sales.
The online store. So this is similar, I said, again, to fanciful for many reasons. One is, again, this can go on the principal register just like fanciful. And again, it's challenging from a marketing perspective for the same reasons, and this can be addressed in the same way. So again, you take your arbitrary term and you attach the generic or the descriptive term after it to identify to your customers and your clients what it is that you are selling. So I don't see these, to be honest, very often. Usually people either come up with their own made-up words, so a fanciful trademark, or will get to the next, suggestive. It's pretty rare in my experience to see this, but it is a valid approach. The other thing about this that could be a bit more of a problem than even a fanciful trademark is it could potentially be confusing to clients. Of course, something like Apple, say if you're selling on Amazon, people aren't probably going to think you're selling fruit on Amazon. That doesn't really happen. But this can have that additional disadvantage, especially if you don't put the generic or descriptive term after it.
I think this one takes a huge investment in the marketing, because right now when you say Apple, especially in technology, people will directly think about Apple products like iPods, iPads, and whatever, like iPhones, whatever they're publishing. But I think it took them millions, maybe billions of dollars until they came to this point. Same goes for Amazon. When you say online store and Amazon, everybody knows that, like even in Turkey, like everywhere, people will think about Amazon.com. But it took them many years. If you're a private label seller, just an Amazon seller, I think this is not the best idea because, obviously you are not spending millions of dollars in the marketing. Still, you can do it, but that wouldn't be my choice.
Yes, I agree with you. Again, this is rarely seen in my experience, and I think for good reason. I think this is a tricky one to make work, like you said, if you don't have a very large marketing budget.
Yeah.
Next, we have suggestive trademarks. So a suggestive trademark is a trademark that gives your customers and your clients some clue as to what it is that you're selling, but doesn't directly describe it. So, for example, copper tone for sunblock. The idea is you put on the sunblock and, you go out in the sun and your skin turns kind of a brownish copper tone and doesn't turn red, doesn't burn. So it suggests to clients, or customers in this case, the purpose of the product, but doesn't directly describe it. Another example, Playboy for a men's magazine. So, suggests that this is, for men who see themselves as, ladies' men, but doesn't directly describe the content of the magazine. Or Jiffy Lube for oil changes. So it suggests that this is, a quick lube, a quick, oil change for your car. Now I have here that it's arguably descriptive, and we'll talk a bit about this when we get to the next slide, and we talk a bit about descriptive trademarks. So the general danger of suggestive trademarks is a lot of them really skirt the line between suggestive and descriptive, and this can become a problem because although suggestive trademarks are given full protection, so a suggestive trademark can go on the principal register, get full trademark rights. A descriptive trademark, however, cannot go on the principal register. And so when you're selecting a suggestive trademark, it's very important that you don't skirt into the area of descriptive trademarks. In general, with suggestive trademarks, they're good from a legal perspective. Again, fully protectable, go on the principal register to get you your full rights. They're good from a marketing perspective, at least considerably better than a fanciful or arbitrary, because you're suggesting to your customers, what it is that you're doing. So again, for copper tone, you're suggesting that, use this product and you're going to get that, copper tan that you want when you go out, tanning on the beach. However, the danger is that if it becomes a little bit too suggestive, it can become considered descriptive. So I think that goes very well into our next point. So a descriptive trademark is a trademark that immediately describes to consumers the nature of the product. For example, cold and creamy for ice cream. All ice cream is cold and creamy. So how can that term really differentiate your ice cream from your competitor's ice cream? 104 key for a keyboard with 104 keys on it. And this will go on generic, it's arguably generic. So, it's just a standard of keyboard. So how, if you're trying to claim that as your trademark, and your trademark is just a certain standard of product, well, how does that differentiate your product from somebody else's product? Now, compare that to, say, Jiffy Lube. I think Jiffy Lube probably is suggestive because, first of all, not all oil change places are necessarily going to be fast, but also because Jiffy, it's not a commonly used word. Do it in a jiffy does mean do it quickly, but I think something like Quick Lube would be worse because it's a lot more commonly used, and it seems like you're just describing, an oil change place versus Jiffy Lube. You could argue that's a bit more inventive. People have to think a bit more about what that means together. The legal standard is that if there is, it's called a leap of imagination or a leap of thought required to get from the trademark to the goods or services, then it's suggestive. If there's no leap required, if you look at it and you immediately know what this is, then it's descriptive. Yeah. But again, sometimes this is something that that you might have to argue with the USPTO with or your attorney with. Now, as I said, this is bad from a legal perspective. If a trademark is considered descriptive, you cannot get it onto the principal register. Now, what this means is you might still get, your supplemental registration. You can still use the R if you get it. You still get a registration number. This can be useful because in many cases, all you need, say you find somebody else who's using your trademark, all you need to stop them is to have an attorney send a cease and desist letter. Say our client has a registration. Here's their registration number. Immediately cease and desist use of our client's trademark. And a lot of other people, especially if they're a small company or an individual, selling their goods, they're not going to want to deal with a lawyer. So as soon as they get that letter and they see that, okay, they have a registration number, here it is, they're just going to stop, they're going to rebrand, they're going to back off. So
yeah, actually, I will make a little quick addition here. Actually, it works the same way like this with Amazon, because Amazon doesn't really look in depth if it is the principal registration or not. As soon as you have the brand registered and then you send them a cease and desist letter, they just make the other party move away. So I think in Amazon's case, it would work as well.
So as far as I know, to get your own brand registered, though, you do need a principal registration for Amazon.
Oh, yeah.
But so I do not believe that this will work to get your own brand registered. But for just so what you could do, though, you could send the letter to the actual party. You don't have to send it to Amazon, and they might rebrand. The risk is it really depends on the party. So there's a big issue, especially on Amazon, with Chinese companies, selling counterfeit products or selling things under other people's trademarks. In my experience, they are not very receptive to any kind of, cease and desist because they're in China, so they're pretty much unreachable under U.S. law, so they don't care. So in that case, you would need the brand registry with Amazon to force them off, and you do want, at least currently, as far as I know, you do want the principal registration to get the Amazon brand registry.
That's actually very important to know. I didn't know this myself. So I like to highlight this. So in order to apply for the brand registry program, version 2 right now, you have to have the primary registration, right? Principal registration.
Yes. The last point on descriptive trademarks is that they can become stronger over time. So there's this idea of acquired distinctiveness. And the idea here is that even if your trademark starts out as descriptive so that customers can't tell that it refers to your specific brand because it just describes all products in that area, if you can put up a good argument to the USPTO that your product has been in the market already for a certain amount of time. The standard time they usually ask for is 5 years, but it's actually not a hard requirement. For example, McDonald's has gotten their descriptive trademarks moved to the principal register after only a year in commerce because they've been able to show that they've had millions of sales under this trademark, and so it's become distinctive when people see some of these trademarks. Even though they're descriptive to start, because McDonald's is such a huge brand, they can show just after a year that they've gotten this distinctiveness. Now, this is really, it can be very tricky to do because there are certain trademarks that the USPTO will say are so descriptive that they can never get acquired distinctiveness. But something like 104 key, I don't think that can ever be acquired distinctiveness because it is very clearly just a description of the product. The keyboard literally has 104 keys on it. So this is a tricky thing. However, if you have a descriptive trademark that you're really married to, you really want to try, if you have been selling under that trademark for 5 years or more and you can show it, talk to your trademark attorney, and they might be able to file what's called 2F, and that means that right at filing, you're already claiming acquired distinctiveness based on 5 years in commerce. But for any small company, for any Amazon seller, I'd really say you need to have those 5 years because the McDonald's 1 year kind of argument is probably not going to work if you're not McDonald's.
It's not relevant, huh?
So, and one last point on descriptive. So, as I said previously, there can be a fine line between descriptive and suggestive. And I've had cases where clients' marks have been initially refused as descriptive. And what we can always do is we can always draft a response to the USPTO arguing that it's not descriptive, it's actually suggestive. And for a lot of these fine line trademarks, you can push them over the edge and they might back off on the descriptive. And they might say, okay, we agree with you. It is suggestive. But this is definitely something that you should get an attorney to do. This is a pretty, legally deep issue. You have to cite cases. You have to cite the, exact legal standards. The final type of trademark here is generic. So it says no value, can never be registered. So this is just, this is the product. So a very obvious example I have here is rollerblades for rollerblades. A slightly less obvious one is cars.com, which is a website where you can search, different cars for sale at dealers and private sales around the country. And you could say, well, but, they're not literally, they're not literally selling the cars. It's a website that lets you buy cars. But a little kind of tricky thing is the USPTO said, well, cars is a generic term for the products that are being listed on this website. .com is a generic term meaning, website. And if a composite of generic terms is still considered generic as long as the total meaning is generic. So here, cars.com, cars is generic for cars, .com generic for a website. It is literally a website selling cars. And cars.com, they actually had quite a bit of money. They had attorneys. They went Trademark Trials and Appeals Board to fight it, and they lost each time. My recommendation is do not try to file on a generic trademark. You will not get it. You'll just, you'll waste your money. You can, pay your attorney to try to fight it, but you're not going to win. This is one of those refusals where if it's pretty clear that it's generic, the USPTO is not going to back off on this.
So does the same apply for, let's say, bestcardeals.com?
So that would be descriptive. So here, the word best is what would be called by the USPTO merely laudatory. So I actually probably should have touched on this. So if you use terms like best or good or great, words that just mean that, laudatory, they're saying good things about your product without really giving a lot of detail. They're just saying this is, a very good product. That's considered descriptive. So best car deals, car deals or cardeals.com is probably generic. But because you have best there, which is a laudatory term, it'll most likely the mark will be considered descriptive. So it would probably go on to the supplemental register. But I again would not recommend bestcardeals.com because the chances of getting on the principal register are very low.
I see.
So next, so what to avoid when selecting a trademark. So first is marks that are confusingly similar to other trademarks that are already in use. So as you can probably understand, the purpose of a trademark is to prevent other people from using similar trademarks. But that doesn't just apply to you, that also applies to other people out there in the marketplace. So if somebody else, it has a similar trademark, and you're trying to get your trademark registered, well, the USPTO is going to protect that other person's rights, and they're going to refuse your application based on the registration of that other party. And there's actually two different cases that can happen. So you can have a similar trademark that is actually registered, and if it's actually registered, your application will receive an initial refusal, which your attorney would have to try to argue against, or if it's really bad, they might even advise you, maybe you need to rebrand a little bit. Or it might be a confusingly similar trademark that's pending. So during the filing process, the priority of filing gets you prior rights, at least during that filing process. So let's say that I file for a trademark today and you file for a trademark tomorrow. The USPTO is going to look at my filing date and they're going to say, okay, you filed a day later, so this guy that filed before you, for now, has superior rights. However, they're not going to out and out refuse the application. What they're going to do is they're going to suspend it. And they're going to suspend it and basically put it on ice until the prior filed trademark resolves. Because maybe the trademark that I filed is flawed for some other reason. Maybe it's generic. Maybe there's something else wrong with it. And if it is, then they're going to refuse my application. And if they refuse my application and it ends up becoming abandoned, well, now there's no more confusing similarity issue for you, so you can go forward. Now, the way to avoid this is you have to do a search on the trademark electronic search system. And really, it's recommended that you have an expert do this. If you come to me at the Trademark Garden, I can do this for you. You can also do it yourself, but the problem is that even if you know how to use the search interface, you have to be familiar with the rules that the USPTO uses to actually cite trademarks against you. And if you're not familiar with those rules, you could get stuck.
Exactly, I agree with you on this because, we used to, at least a couple of times, we tried to do this on our own. And for one reason or another, each time we failed. Like, I strongly advise that, like, anybody that's going to make an application to work with an expert, especially on this. Like, the chances that you are going to be failing is so high.
Yeah, this is very tricky. And so of people filing trademarks for themselves, between 80 and 90% receive at least an initial refusal. For many reasons, but this is a big one. And it really is tricky to do a search properly. I mean, sometimes even somebody who is trained in it will miss something because there's so many different permutations and so many different issues. But somebody who's trained in it will have a much higher success rate than somebody who is just trying. So the second point is common law searches. So under U.S. trademark law, just using a brand in commerce gets you certain rights to that brand. The problem is that those rights, well, there's actually two problems. The problem number one, those rights are regional. So let's say that you're selling under a brand and you can show that you've sold in Florida and North Carolina and Texas. Well, you have rights in Florida, North Carolina, and Texas, but you don't have rights in the 47 other states. That's not very good because, you probably want to sell to all the states. And then problem two is it's one of evidence. So if you're just relying on common law, you have to be able to show, the regions that you've been selling in. And even then, the court might say, well, these sales aren't significant enough to get you common law rights. So it's not something you should lean on. However, this can occasionally be a problem. So sometimes you will file for a trademark and sometimes you will file for a trademark and somebody else will see your filing and they'll say, wait a minute, I've been selling, these goods under a similar name for years and years and years. And you're infringing on my common law rights. And if you don't withdraw your application, I'm going to oppose it or I'm going to sue you. So this can be a problem. It's not very common. And the reason that it's not very common is because so the way they would find out about your application is they would have to do their own trademark search and they'd have to find your application. Usually the only parties that are doing trademark searches, well and often enough to find these things are large companies. So again, your Bayer Pharmaceuticals, your BMW, McDonald's, all these huge multinational companies everybody's heard of. And they all hire lawyers, and part of what those lawyers do is every month they will just go and do huge searches of everything that's being filed, and they'll cross-reference that against their clients' registrations, and then if there's any problems, they'll send out letters. But if somebody has so their operation is so small, they have so little money, they have so little sophistication that they don't even have a registration, all they have is common law rights, then really what are the chances that they're going to be doing trademark register searches and even find your application to begin with? So this is a very rare thing that a common law challenge comes up. However, the good news is that it's easier to do a search for a common law challenge. You can have, again, an expert do this for you, but just using Google will generally get you at least okay results.
Myself, actually, I didn't know about USPTO until I started selling on Amazon. So I believe most people won't think about searching for trademarks on the specific trademark search engine if they are not really into the business.
Right. But that actually goes right into my point. So let's say that you were selling goods to the U.S. Let's say that you were selling to all 50 states under a certain trademark or under a certain brand name, right?
Yeah.
So you had common law rights just by the fact that you had those sales.
Yep.
But and let's say somebody filed to try to get a registration. They filed on the official USPTO, through the official process. You technically had superior common law rights, but if you didn't have a registration, you didn't know about the USPTO. What are the chances that you will ever find their application and challenge them with your common law rights?
Exactly. Yeah.
Not very high, which is the problem with common law rights. You have them on paper, but then what are the chances that you'll be able to effectively enforce them? Not great.
It is a very slight percentage, I guess I would say.
No.
But on the other hand, that means that for filers, common law challenges are very uncommon.
Yeah, makes sense.
So next, scandalous marks. So this is trademarks that basically contain, curse words, dirty words. So this is actually currently undergoing court review. So there was a big Supreme Court case that was just decided last year, in which so it used to be that any trademark that was considered disparaging to a person or to a group could not be registered. And the scandalous marks, which are just trademarks with, dirty words, could not be registered. But there was a rock band called the Slants. And slant is, in English, it's a slang kind of pejorative term for East Asian people. Yeah. And, but this rock band was all composed of Asian people, and they said, look, this is our band name, this is what we want to call ourselves, and they said that it was unconstitutional. Under the First Amendment, they said that we have freedom of speech to call our band what we want to call our band, and we want to be able to protect our brand, and the government can't unilaterally say we can't protect our brand because they disagree with our speech. And the Supreme Court agreed with them and said, yes, this is an unconstitutional limitation on your speech, and they let them get the trademark for their band name. Now, and they struck the entire portion of the trademark law which said that you could not have disparaging trademarks. However, scandalous trademarks are technically under a somewhat different part of the law, so that part wasn't struck by the Supreme Court. So, in theory, scandalous trademarks containing dirty words, sexual words, are still not allowed. However, there's another case moving through the courts, and so far it got to the federal district, and the federal district ruled that preventing the registration of scandalous marks is also unconstitutional, and scandalous marks should be allowed to go forward. However, because the federal district court's decision is still reviewable potentially by the Supreme Court, it's technically not considered a decided issue yet. So what this means for people is that if you file on a scandalous trademark, something containing a curse word, it'll be suspended. and the USPTO is going to sit on it until there is a final, court decision that is not appealable as to the registrability of scandalous marks.
I think there is another issue here. Like, even if you manage to get a scandalous mark registered, Amazon might still say, okay, you know what? Like, I don't accept this dirty word as a trademark on my platform. So I would say, like, everybody should stay away from scandalous mark if they're thinking of selling on Amazon.
I agree. And it's important to keep in mind that, Amazon is a private party. The Amazon brand registry has certain requirements, which include registration on with the USPTO and certain other requirements. Again, I'll give you a link to a page that I made talking about that a bit more in depth. But they are a private company. They can refuse your registration for any reason that they might potentially decide, and they're within their rights to do so. So I agree. I would not file on a scandalous trademark if you plan on filing on Amazon. So next, merely surname. So if your trademark is just your last name or somebody else's last name, and the only interpretation is that it is a last name, then it will be refused for the principal register, and it'll have to go on supplemental just as with a descriptive trademark. But it's interesting. So it has to be merely a surname. So, for example, Washington. Washington is a surname. It's a last name, but it's also a state, but it's also a city. So there you can argue that, well, it's not merely a surname because it has other meanings. Or, certain last names are also words or have certain meanings. So you could argue, if you have a last name that also means something, you could argue that, well, it's not merely a surname because it also means something, so it's a double entendre. When analyzing this, the USPTO will look at a few factors. First of all, they will look at if it's actually your last name. So if it's actually your last name you're filing on, then that's kind of bad for you because that leans toward you just filing on a last name. They'll look at how common the last name is. And they'll look at, combined with that, how likely are people when they see this to think that, oh, that's just a last name. In general, I would try to stay away from this, and I'd also try to stay away from, so if you combine your last name with a descriptive term or a generic term, so, Johnson's hats or whatever, so you have your last name and then the generic term, that's not good. That's going to be considered descriptive or primarily merely surname. That's not going to get on the principal register. So for the most part, I would stay away. What you can try to do is, come up with something clever. Maybe take your initials and take, the first letter of what you're selling and combine that into an acronym or something like that.
Yeah.
Sorry, let me just do this. Sorry.
That's right. For instance, my last name is Tuna, so I think it wouldn't be a good trademark.
Well, again, it depends, because if your last name is pretty uncommon, you might have an argument that it's uncommon enough that people would just think that it's a fanciful word. But you should stay away from filing with your last name. What's interesting, though, is that note that I didn't say first name, I said last name. So you can file on your first and last name. And I guess you could argue that, tuna is a type of fish, so I guess you could argue that it's not merely a surname because it has this other meaning. So you'd have a bit of a shot there.
But it is kind of generic too. But I think I will still stay away from it, though.
In general, I would recommend against it. Geographically descriptive. So this is trademarks that describe the origin from where they come from. So, for example, if you are, from Turkey and you are selling phone accessories, Turkish phone accessories is geographically descriptive. Or even just Turkey would be considered geographically descriptive because you are just giving the source of your products. They are being sent from Turkey, or they are made in Turkey, and they are therefore Turkish products. Now, you can't get around this by picking some other place. So let's say that you're in Turkey, but you want to call your Paris Paris clothing line or Paris perfume. That's going to be considered geographically misdescriptive. So if you are using some geographically identifying term that is not the actual source of your products, and if the USPTO can make any kind of argument that the term you're using, that geographic location, is appealing to people. So if you're selling perfume and you call it Paris perfume, well, a lot of people want French perfume. So if you're calling it Paris perfume, even if you're located in America or Turkey or Russia or anywhere else, you can't do that. The USPTO is going to refuse your application entirely, actually, because they're going to say you're trying to deceive people into thinking that this is French perfume, and it's not. So, be very careful. And in general, I would generally stay away from these kinds of terms. You can occasionally get away with it. A good example is Patagonia. So Patagonia is a region, in Argentina, and it's a brand for outdoor gear. And the argument that is made is that, well, it's not made in Patagonia. There's no special reason for people to want things made in Patagonia. There's nothing's made there. It's just describing that this is gear for a rugged environment like the kind in Patagonia. So if it's something like that, you can potentially make an argument that'll get you around geographic descriptiveness. But first of all, expect an initial refusal and expect to have to pay your attorney to try to argue against it. And even then, it might not work. To put it in a simple way, without getting too lost in the legal technicalities, if your trademark is just a geographic term plus descriptive terms, it's not going to get on the principal register. And if it's not going to get on the principal register, you're not getting the main protections that you want, so stay away. And in general, I would stay away from geographic terms entirely because they tend to create a lot of trouble, and I don't think they give you that much of an advantage, especially if you're just selling something on Amazon. I don't think they help you very much.
Yeah.
Next is famous marks. So this is a subcategory confusingly similar. So normally for a trademark to be considered confusingly similar, there has to be 2 points of overlap. One is the trademark itself has to be similar. So, the words have to be similar. Or whatever the words or the logo, the appearance has to be similar. And number 2, the goods or the services have to be similar. However, if a trademark is considered famous, and it's hard to say exactly what this is, but it's one of those things where usually, if it's something you can think of off the top of your head, it's famous. Nike, McDonald's, Starbucks, Mercedes-Benz, Coca-Cola, all these trademarks you just think off the top of your head, they get a broader level of protection. So even if the goods maybe don't match exactly, there still is going to be a likelihood of confusion that is probably going to be found. I remember I once had a client that wanted to file for Jeep, G-E-E-P,
Really?
for various things that have nothing to do with cars. But I told him, this is not going to work because Jeep is a famous trademark, and it's going to have protection for all kinds of things because it's so famous, so you're not going to get this. And actually, the other part here is these are the companies that hire lawyers to do nothing but search the applications and see if there's anything being filed. So even if the USPTO were somehow to let this pass, the actual rights owner of the famous trademark is going to come after you, is going to send you a cease and desist, and they might even sue you. So stay away from famous trademarks. Stay away from the names of famous people, from their nicknames, from anything like that. Just don't touch it. Come up with your own brand, and you'll be a lot happier in the long run. And the last point here is cute and clever misspellings of descriptive, generic, and confusing similar trademarks. So the USPTO generally doesn't. Let's say that you, let's look at cars.com, which was found to be generic. Let's say it was cars with a Z.com. That would still be considered generic. The USPTO, whenever they look at, what appears to be an intentional, like cute misspelling with a Z instead of an S, or, an F instead of a PH or whatever, they're going to, when they analyze that, they're going to look at it as if it's not misspelled. And they actually assign what's called a pseudo mark to it. So let's say it's cars with a Z, they're going to look and they're going to search under the pseudo mark cars with an S. So if they find, any conflicts on the actual spelling, that's going to be cited against you. If the actual spelling is generic, it's going to be cited against you. If the actual spelling is geographically descriptive, it's going to be cited against you. In short, cute misspellings do not help you at all. So don't even try it. It's not going to work. Now, on this point, I actually also want to touch a little bit on the use of logos. So we talked about descriptive trademarks, geographically descriptive trademarks, and all of these things. Now, it is possible to kind of get around a lot of these issues by filing a logo. So let's say that you have some visual design, pictures, shapes, images, and you also have words. So, a good example, let's say Nike. Nike has the swoosh, which they sometimes use on their own, but sometimes they have the swoosh and the word Nike under it. But let's say that you have a design like that and then descriptive terms. So, say you have a design, and then, let's say for ice cream you have cold and creamy, but you also have an image of, a snowman eating an ice cream cone, and then cold and creamy. So if you have an image of a snowman eating an ice cream cone, and then the words cold and creamy under it, you can probably get that registered as a logo. And that whole thing as a logo will go, and you'll get the trademark. Here's the problem, though. The USPTO will register the whole thing, but they'll force you to disclaim rights to the descriptive wording. So they'll make you disclaim cold and creamy because they'll say cold and creamy is just describing the ice cream. They'll say, so the distinctive portion is the snowman eating the ice cream cone. That's fine. But even though the entire logo will go onto the register, it'll show up with the words there. Legally speaking, they will make you disclaim your exclusive rights to the words because the words are descriptive.
I was actually going to ask you about this. Do you know if you can apply for brand register on Amazon only with the logo?
Yeah, so that is the one. That is though the advantage. So this is pretty recent. Amazon brand registry used to not allow logos at all, and they used to require word marks, but now they require logos. So they actually, because this change is recent, I actually haven't had experience with a logo where all of the word portions are disclaimed. But given the way that the rules are currently written, it appears that this should be possible, yes. If you have the logo, let's say the snowman, cold and creamy, that entire thing goes on the principal register, and then you apply to the brand registry with the logo, including the words. That should be able to get onto the brand registry, yes, because it would be on the principal registry.
If that is the case with the new change, I think it opens a whole new corridor for Amazon sellers, because I think then it's going to have a lot more advantages, like compared to the old style of having trademarks.
Yeah, and this is pretty new. This is only a few months old, really.
I didn't know about it myself, so like it's really crucial.
Yeah, and this is a good way. The only problem though is that if you then have the brand registry on the logo, again, this is in Amazon's ballpark. This isn't any government rules or actions. But let's say you have the snowman and cold and creamy for ice cream. and I mean, nobody sells ice cream on Amazon, but let's just say for the sake of argument. If somebody else has ice cream and they're calling it cold and creamy, but they don't have the snowman, Amazon might not enforce that because they might say, well, your logo has a snowman, theirs doesn't have a snowman, so it's fine. It's hard to say how Amazon would actually follow through on that. So I would say, as a matter of practice, I would say it's still best to have a trademark, a word trademark that can get onto the principal register, get that brand registered, and then you have the best kind of protection. Mm-hmm. But if you're really married to your descriptive trademark, then doing a logo can get you there. The one other caveat that I want to say, if you want to take this route, you really have to put an image on as part of the logo. You can't just use fancy font. You can't just use. So let's say that you write cold and creamy in very creative script letters, and you file on those very creative script letters. That's not going to work. That's still going to be considered descriptive by the USPTO. And if you use a very simple shape, let's say cold and creamy with a rectangle around it, it's not going to work either. You need something that's quote-unquote distinctive, usually images, little characters. If you're going to use shapes, try to make some geometric arrangement. Don't just use a square. Don't just use a triangle. Don't just use a circle. You want to create something more, something that makes it look more like a visual design rather than you just trying to sneak words in as a logo by putting a square around them, because they're not going to accept that.
I was just going to ask about those, actually, about the restrictions they might have with the logos. Are you aware of any other restrictions that could be there?
When you say other restrictions, do you mean...
apart from how big the words have to be, or the logo and the distinctiveness and stuff?
No, so generally, you can... So there's two general types of trademark filing. There's technically more, but for our purposes, just understanding these two is sufficient. You can file on a word, and then if you file on a word or words, you get protection of those words in any font and any color and any capitalization scheme. Or you can file on a logo, and if you file on a logo, then your protection is limited to your particular stylization. You can actually choose not to claim colors, so colors kind of out, but the font and the designs and everything. Mm-hmm. And then that particular stylization will be protected. There's no real restriction per se. In fact, if you want, you can just write something out in block letters and file on that as a logo. Mm-hmm. But there's no reason to do it because let's say you write out cold and creamy in big black block letters and file on it as a logo. They'll take it as a logo filing, but they will still claim it's descriptive because it's not. It doesn't have visual designs. So they'll just say it's a non-distinctive logo, and there's no point because you're not getting anything extra. You're not allowing it to bypass the descriptiveness risk. So in order to allow a logo to bypass the risk, it really needs to have those visual elements, which is why if you're going to file on a logo, you should have distinct visual elements. You should have something more than just creative font. Because if it is just creative font, don't bother, just file on it as a word. But if you do have a picture, then filing on a logo will help you in two ways. Number one, if your picture is actually an important part of your brand, you want that protected. So for Nike, the swoosh is a very important part of their brand. They want that protected. It's not just about trying to get around anything. It's about protecting the image that's important to them. Number two, if your words are descriptive, then if you combine it with the image, you might be able to get past the descriptiveness risk for the logo. Yeah. Does that make sense?
Yeah. All right.
So, okay, and finally to kind of wrap up, we have what you would need for your application. So, well, first off, deciding on if you want a trademark. Obviously, this has to be something worth protecting, and the things you really want to think about are, first of all, what happens if somebody intentionally or otherwise copies your trademark? Well, there are a couple things could happen. First of all, they might file for registration, and they might try to force you off of your trademark. Again, technically, you would have common law rights if you have prior use, but now you're stuck with a bunch of legal costs trying to prove that. And without the registration, that's going to be time-consuming and expensive to prove. And you're going to be a lot better off if you get your registration, you spend a few $100s if you get your registration, rather than spending thousands of dollars trying to prove your common law rights, and even then they might be regional. Like I said, it's by state. Otherwise, you'd have to rebrand. So, you'd have to change your name on, your point of sale on Amazon or whatever you're using. If you have a website, you're going to have to change all of your information there on your, Facebook, social media. If, you have clients who are coming back to you, customers who are coming back to you, people that like your products, they're going to be confused. Why are you not called that anymore? What happened to you? If they refer out, people might not, be able to find you based on their referral. It's a pretty serious problem, and in most cases, at the very least, getting a word trademark for your name, for your business name, for your seller name, yeah, it's going to be a couple $100, but it's going to protect you potentially if you keep renewing it forever. So the first renewal is due between 5 and 6 years after registration. So you get, basically 6 years of protection from the initial registration, and then every 10 years thereafter. But, it's like an insurance policy. You just pay it up front, and now you're pretty well protected against anybody forcing you off, or even somebody else trying to copy you. And now somebody else is trying to sell similar things under a similar name. They might not be going after you, but as I said, it can be a shield and it can be a sword. You can take your trademark. You have to, you can try it yourself, but generally you want an attorney to send them a letter and say, look, our client's got registration, and if you don't stop using their intellectual property, they have a case to sue you, and usually, if this goes through, the damages are the profit. So basically, they can take whatever profit you're making in this business when you're selling your goods, they can sue you for that amount. They can take all the profit because you're using their trademark. You're using their intellectual property to present your goods. And that's majority cases. It's pretty convincing. And like we said, with Amazon brand registry, even let's say the seller is in China and they don't care if you threaten to sue them, but you get the trademark, you get on the brand registry, you can get Amazon to remove them, even though they're unreachable by the regular U.S. legal process. If they're selling on Amazon, they're reachable by Amazon, and you're going to need a trademark to get on the brand registry. And once you have that, if somebody's ripping off your brand, if somebody's ripping off your stuff on Amazon, you have that, and you get Amazon to remove them.
Yeah, let me add this. Like, if you want to be serious, like if you don't see Amazon as your side job, if you want to be serious on Amazon, you have to have the brand registry. Otherwise, I can 100% guarantee that like today or tomorrow, just one day, your listing is going to get hijacked. It is going to happen. Like once you start making some money, especially most likely a Chinese seller is going to hijack your listing. It's going to happen. And therefore you have to have the brand registry. Otherwise they won't let you succeed on Amazon. It's impossible.
You have to think of it as an investment.
Yeah, yes, it's an investment. It's an asset that you have to consider buying. Otherwise you can't manage.
And as I said, it's not even like it's a huge amount of money.
Yeah.
I mean, for the application, even if there's some initial trouble, I mean, let's say that there's an initial refusal, that your attorney has to work something out with USPTO. I mean, your total outlay is probably going to be below $3,000 almost certainly, and a lot of times you'll be able to do it for below $1,000.
Yeah.
Even having a professional do it, and it's not for a business. That's not a huge expenditure to ensure that you're going to be able to prevent your listings from being hijacked for years and years and years to come. Hijacking will cost you a lot more than paying for a trademark. I can guarantee you that. Just imagine you started selling well, and you wake up one morning and you see like other 5 sellers competing for the buy box on your listing,
And the worst case is going to be that they won't be even selling the same products. They're just going to be shipping some weird product from China or another country that doesn't even look like yours. And by the time you persuade Amazon or just the seller himself to get away from the listing, it's going to be too late, because the customers will have received their new products which actually doesn't look like yours, or which is actually a lot worse, and then you will start getting one-star reviews, and it is going to ruin your business. You have to have the brand register. It's a must.
And the first step is you get the registration with the government, and then you get the brand registry.
Yep.
And it really is. I mean, it's from a business perspective, and as far as business costs go, it's not a huge cost, and it protects you from so much. I mean, if you're serious about your business, if this isn't just a hobby or something you're doing on the side, but if this is a serious endeavor where you're trying to build your brand, you're trying to build your recognition, you're trying to get clients, you're trying to get customers, absolutely, at the very least, trademark your name. Really, trademark your name, trademark if you have a product line that has a certain brand associated with it. If you have a product line with a certain name, trademark that. If you have a certain logo or image you're using, trademark that. But at the very least, trademark your name. It will save you so much money, so much headache, for years and years. So finally, ready and willing to force the trademark, you need time, money, and gumption. So I think another takeaway is if you actually have the registration, it'll take a lot less time, a lot less money, and a lot less gumption than if you're trying to protect your brand without the registration.
Deal with the hijackers, especially on Amazon.
Yeah. And with hijackers on Amazon, in my experience, if the person, I've had people come to me where their brand's been hijacked where they don't have a registration or a brand registered with Amazon. Amazon's not really willing to do anything necessarily if you don't have some way to prove that you are the legitimate rights owner.
Actually, I understand Amazon's point of view, because Amazon actually tells you that. Amazon tells you, first you show me that you are serious about your brand. Then I will start covering you. That's what Amazon is telling people to do. We need to show Amazon that we care about our brand. We actually do something to improve our brand. That's what Amazon wants to see.
Yeah, at the end of the day, once you don't have the brand name, what's going to happen is some other people is going to come. They're going to hijack your stuff. It's going to be good for Amazon because the price is going to come down, and they're going to get some money from the advertisement, etc.
Yeah, otherwise you are just a generic seller to Amazon. You have to protect your brand.
Okay, but luckily, it's work that I'd be willing to do for you. Just get in touch, and we'll be able to get you on your way to your federal registration and to your Amazon registration. So on that point, this is my information. I can be reached at Anton@trademarkgarden.com, and trademarkgarden.com is my website. Let's just go there real quick. So, as I was talking about, I actually have an article about the brand registry on here. So I have an article talking about this, and it's mostly about the different types of trademarks that are admitted onto the brand registry. If you're curious about it, I'd recommend.
Actually, with your permission, I can translate this to Turkish and publish it on my blog with a direct link to your webpage. So Turkish audience can actually come and see your services directly from my blog as well.
Yeah, please do. Just include a link to my webpage, and you can please do use it.
Anton, we know your time is very valuable. We thank you so much.
It was really comprehensive, and I myself learned many things I didn't know before. So I really appreciate it, Anton, so much. Thank you so much.
Thank you very much.
Thank you, guys.